Yes.
Mullahs, this is indeed, Mullahs, according to me, a historic moment in many ways. First, Mullahs, that your Lordships will be analyzing why history was tossed out on the 6th of August 2019. Whether the procedure adopted by Parliament was consistent with what democracy stands for. Whether the will of the people of Jammu and Kashmir could be silenced in this fashion. Whether they will be denied a representative form of government through a diktat of the Union inconsistent with our Constitution. It is also historic because it has taken 5 years for your Lordships, Mullahs, to start hearing this case. And for 5 years, Mullahs, there has been no representative government in the state of Jammu and Kashmir. It is also historic because you will have to interpret Article 356 of the Constitution of India. An article which seeks to restore democracy. And how do that process through an article which sought to restore democracy? You have decimated democracy. Can that be done under Article 356? That the state of Jammu and Kashmir historically represented a very unique relationship. Unlike princely states and the states of India which were integrated into the Union. Whether that historic relationship between sovereign authorities could have been jettisoned in this fashion by seeking to amend the Constitution and seeking to efface Article 370. Whether, Mullahs, a governor of a state could have, on the 20th of June 2018, decided that I will keep the assembly under suspended animation, which is the power of the governor alone under the J&K Constitution, without even trying to find out whether they can form a government or not. Because on the 19th of June, a particular party withdrew support, and on the 20th of June, the governor passed this order. Whether on the 21st of November 2018, Mullahs, a dissolution of the assembly could have taken place before the imposition of Article 356. The governor on the 21st of June dissolved the assembly without reference to 356. And thereafter, Article 356 was used. And the manner that it was used will be, Mullahs, I will address your Lordships on those issues. These are issues that will arise for your Lordships' consideration, never raised, never decided by this court. So in that sense, too, it is historic. So, Mullahs, I will proceed because there is a historical context to the state of Jammu and Kashmir, Mullahs. So I will have to take your Lordships through that history. And if your Lordships will permit me, Mullah, I'll start with a list of dates.
Mr. Sibal, as all counsel know that all the arguments, we have the benefit now of live transcription. So the arguments are being simultaneously, we have transcripts in the court on the basis of, speech to text software. Like in the Maharashtra case, by the end of the day, the transcripts will be given to the arguing counsel. Your juniors can just verify that there are no mistakes. If there are any corrections, they can be given to the registry so that we will upload them immediately on our website. So they are available for everybody then to, that will also help counsel who are following. Of course, it helps us as well as everybody else.
So, Mullahs, I'll start off with the list of dates, which is, Mullahs, volume 2. Mullahs, before this, may I, Mullahs, want to make one statement clear, Mullahs, that we stand here on the premise that the integration of Jammu and Kashmir into India is unquestionable, was unquestionable, and always remain unquestionable. That was a given. And despite that, Mullahs, the whole structure was overnight, Mullahs, changed through a process which I will demonstrate was unconstitutional. When your Lordships will be dealing with this matter, there will be 4 legislations in a sense that you'll be dealing with. One is the Constitution of India. The second is the Constitution of India as applicable in the state of Jammu and Kashmir. Third is the Constitution of Jammu and Kashmir. And fourth is Article 370. And the interaction between these 3 constitutions in the context of Article 370 is something that your Lordships will have to look at as we move forward. But please keep that in mind. The reason why I say Constitution of India is applicable to the state of Jammu and Kashmir, that over time, there were several orders issued, constitutional orders from time to time, which were incorporated in the Constitution of India applicable to Jammu and Kashmir. The result was that most of the powers most of the responsibilities and powers were actually in tandem with the Constitution of India. There was in fact really no difference other than Article 370 itself. All the laws were applicable, except that those laws were replicated in the constitutional orders of the Government of India. Therefore, there was no reason to take away this right. It's in that context, Mullah, that I'm mentioning this. Now, Mullah, I'll go to the list of dates. On the 9th of March 1846, the Treaty of Lahore was executed between Maharaja of Lahore and the British government, resulting in the transfer of certain territories to the East India Company. In particular, under Article 4 of the treaty, the Maharaja cedes to the Honourable Company all its forts, territories, rights and interests in the hill countries which are situated between the river Beas and Indus, including provinces of Kashmir and Hazara. Well, there's just two issues I want to flag here. Your Lordships, in the course of this hearing, will have to determine what does a Constituent Assembly stand for. A Constituent Assembly stands for enacting a constitution for the future of the territories with respect to which the Constitution is to apply. It's essentially a political exercise. It's not a legal exercise. It's a political exercise to take into account the aspirations of people, what kind of state the people want, and in the context of that, draft a constitution. The Constitution itself is a political document, but it takes into account the aspirations of several segments of society living within a united territory, takes into account their separate aspirations, and in the context of that, drafts a constitution to meet the aspirations in future years for decades to come. So the exercise of a Constituent Assembly is a political exercise. The drafting of the Constitution, which is a political document, is a political exercise. But once the Constitution is drafted, once it is come into place, then all institutions under the Constitution are governed by the Constitution. And those institutions are limited in the exercise of their powers because they have to exercise their powers consistent with the provisions of the Constitution. Parliament cannot convert itself into a Constituent Assembly. That's done. Today, the Indian Parliament can't say by a resolution that we are the Constituent Assembly. As a matter of law, they can't say it. Because they are now cabined, cribbed and confined by the provisions of the Constitution. They can't pass a law which is outside the list. They can pass a law under 254. If the state passes a law, it's repugnant. They must adhere to the basic features of the Constitution. They can't suspend, except in emergencies with external aggression, the fundamental rights of people. That also is limited under provisions of the Constitution. The executive can't do things which are contrary to the law, and the judiciary then declares the law. But no parliament can convert itself into a Constituent Assembly. And if you accept that proposition of law, it has enormous consequences for the future of my country. And that is one of the most salient and, according to me, the core issues to be decided in this case. Because Parliament said that we declare the legislature of the state of Jammu and Kashmir as the Constituent Assembly. Where does Parliament get that power? How does Parliament get that power? Under which provision of law? Not under 356. So that's, according to me, the core of the issue that your Lordships will have to decide. May I now, with your Lordships' permission, read the instrument of accession? Because what happened on the 26th of October, actually, the invasion, so to say, was started on the 20th of October. And within 6 days, these decisions were taken. Because the invaders came, they were armed, they had guns, they would have run over the state. The ruler realized that he cannot secure the security of his own people. He had entered into a standstill agreement with Pakistan. India refused to enter into a standstill agreement with him. And then, thereafter what happened? One second. Thereafter what happened was, that he said, look, I need help, and he told Mountbatten, I cannot possibly secure my people. So thereafter, the proceedings started. He sought, and he said, look, if you help me, I will unconditionally access to India subject to my own conditions, which is separate from the instruments of accession of the other states. And India accepted it, and that's how India secured the peace and was able to And of course, the precursor to that is the Ratcliffe Award, in terms of which the part of Gurdaspur, what connected Jammu and Kashmir to India, was ceded to India under the Ratcliffe Award, which allowed for that contiguity, which was the basic principle on the basis of which the partition was to take place. So that's how all this happened. Your Lordship, just a historical fact, at that point in time, Sheikh Abdullah was in prison. And he had been always against the ruler, because he wanted the will of the people of Jammu and Kashmir, and not a despotic ruler. So he was against the Sadr-e Riyasat, so to say. But when he realized that, look, unless I get him on my side, I'm not going to be able to defend. So he released him and said, you form the interim government.